Hi, everybody. Welcome to Beverly Hills Bar Association presentation, the Family Law Section's presentation on spousal support issues post-judgment. Before we begin our presentation, I'm tasked with giving you some announcements, one of which deals with the MCLE certificate, which will be emailed to you within 24 hours of this program. We also would like to thank the sponsors for the Family Law Section of the Beverly Hills Bar. That would be SoberLink, White Zuckerman, Warsofsky, Luna, and Hunt, and Our Family Wizard. SoberLink system combines a portable breathalyzer and wireless technology trusted for use in child custody cases since 2011. We are the only system that combines court admissibility in all 50 states and Canada, facial recognition and tampering detection, real-time results, easy-to-read advanced reporting. Trust the experts in remote alcohol monitoring technology for your custody cases involving alcohol. For White Zuckerman, Warsofsky, Luna, and Hunt, they provide a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. And finally, as to Our Family Wizard, this is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activities. Our Family Wizard provides a neutral space for parent communication to help co-parents manage the challenges of shared parenting. With its fee waiver program, Our Family Wizard is completely free for parents receiving services from legal aid organizations such as the one presented here tonight. Thank you for your patience in that announcement. Also, before we begin, I want to let you know that there are materials that will be posted in the chat. Natalie did an incredible job of all 30 some odd pages of this program, which answers so many of the questions. And you can probably tell just by the length of that attachment that we couldn't possibly touch on every subject within an hour. It'd taken a day probably to go through all those subjects. But we'll try to tackle some of those things. And again, thank you, Natalie, for putting those materials together.
Thank you, Brian. The written materials were definitely a team effort, and we hope that the audience finds them useful. I also want to acknowledge and thank our two judicial officers who are here today, Judge Richardson in Department 43 at Stanley Mosque, and Judge Roberts, formerly in Department 87 at Mosque, and now serving as a settlement officer in Department Y in Van Nuys, for their contributions to today's program. The topic is post-judgment spousal support modification, and I know our audience is eager to learn from the bench how we as attorneys can improve our pleadings to increase our chances of prevailing on the merits and also make the judicial officers' lives easier in the process. While the judges are speaking, members of the audience may privately message Brian with any questions you would like presented to the judges, which will be asked anonymously. So now I will open the floor to Judge Richardson and Judge Roberts to share their recommendations regarding what to include in the moving papers, what not to include, what forms to use, and anything else they would like to share with the audience.
All right, did you want me to start, Natalie? Or?
Yeah, please.
Okay. All right, well, thanks again for inviting me. I'm always pleased to speak to the bar. And again, the Family Law Bar has been such a great, collaborative presence for newer judicial offices. We really appreciate it. And we're happy to speak with you and answer any questions that you may have. So speaking for myself, I always appreciate it if the parties do attach the judgment. We're talking about post-judgment request for modification, and really make it clear what exactly the prior circumstances were. I think a lot of times people get caught up in the change of circumstance and they talk about the current situation. And sometimes I have to go back and really dig to figure out what were the circumstances when the judgment was entered, Sometimes they're in the judgment, which is great. And that's a tip for those of you, that are drafting those judgments, is to make sure that you put as much of those circumstances and what that was based on, even if it was a stipulation and you never had a trial on all the 4320 factors. I have had cases where people come back and are trying to litigate and dispute what were the circumstances that led to a settlement, and was the income, what was the income and all of that. So one thing to remember is just don't forget the first part of the change of circumstances, and in your haste to focus on what's new and changed. Then I'll just add also that I do find it useful to use the FL 147 form for a couple of reasons. Even if you've got, the best attorney in the Beverly Hills Bar Association, if you are the best attorney, if your client has the best attorney, it's still helpful to start there for a couple of reasons. We can, instantly go and look at the form when we want to know the age, when we want to know what are the assets. And
Your Honor, I think you said 147. Did you mean 157?
157. Yes. Sorry if I misspoke.
And a copy of that is actually in the materials on page 29 for the members of the audience to refer
Right.
to.
It's the form that goes through all the 4320 factors. And we understand that you want to attach your client's declaration and your declaration, and we want that too. But it is helpful to start with the form and to include the form so that things that you can include there, we can see them and go right to them. I also think it helps you not forget that when we want to modify spousal support, we can't just find a change of circumstances. We do have to go through all those factors. So sometimes people in their rush to write their declaration about the change, they don't necessarily go through all the factors. And then again, that's something that we have to deal with in argument or, sort out and fish through. So those are a couple thoughts I have. Happy to have Judge Roberts add to that.
Thank you, Judge Richardson. And thank you to everybody for attending today, and especially to Brian and Natalie for putting this together. And I want to echo what was said previously about the papers. They're really outstanding. So I commend those to all of you. It's a little intimidating, in fact, to be sitting here. I feel like I'm taking an oral exam and all of you have the answer key. But we can at least give you some, I can at least give you some tips and some practice pointers that are helpful. I think Judge Richardson has gone through a lot of really important ones. Just a couple of things to add to that. The FL 157 is a really convenient form. I've heard from a number of lawyers that it feels rinky-dink to use those forms. Use those forms. You can always do a P&A. You can always do a lengthier declaration, but that should be a standalone summary sheet, because that's the first place that I'm going to go after I've dealt with the change of circumstance that Judge Richardson was talking about. And it's good. It's like a summary of argument. It's there. Please don't put, see attached declaration, which I take as an invitation to go on a treasure hunt, which at 8 o'clock on Sunday night is not really what I want to do. So lay it all out there clearly and concisely and use that form. It's really, really helpful. Another thing that comes up a lot is you'll see very bare bones initial papers filed, and then the ringer reply brief and the scream of foul about the ringer reply brief. And there's a bit of a box that you can get caught in here that I'm going to suggest that the telephone is the answer to. And that box is technically filing the request for order is what reopens discovery. So that's very often the excuse for having bare bones papers. Call up the other side, try to lay out what's going on, try to get a stipulation. If you can't get a stipulation, put that in your papers. Of course, I'd much rather have lawyers work together and figure out that procedural stuff so that we don't have to use any of our brain power on that. But, and then if you can't get the stipulation, you can't get the discovery, obviously retroactivity is a concern. File the best papers that you can with the information that you have, take the discovery, and then if you need to file supplemental papers, do that. I appreciate, as a judge, I appreciate when rather than file a supplemental brief, the moving party files a standalone new brief superseding the old one. Again, that saves the flipping back and forth. It also helps me see at a glance that you're not using all this as an excuse to cheat on the page limits. So that's my personal tip, is to try to think about how you can lay this out procedurally in a way that's going to enable the court to focus on the substantive issues.
Can I just follow up on that real quick? So I would just say that I completely agree with that. And one reason, not to do a bare bones request is you have to have some idea of what the change of circumstances is. And so it really does help to have you put it in there. And if you feel that you are going to need discovery, you can include that in your original motion that says, this is what the new change of circumstances is. This is what we know right now. This is what we are doing for discovery. And we intend to file, a supplemental brief that will, if we need to, depending on what that discovery shows. And then again, at least it clues us in as to why you're asking for it, and that it isn't just a fishing expedition and, somebody asking for something just on the hope that there's a change of circumstances and asking for fees and litigating what may end up not being a change of circumstance.
And then can I follow up on what you guys both said? I was at a program where Judge Riff said he likes to see 4 different sections in each memorandum of points and authorities, whether it's about this particular subject or any subject. The first being, give me details in a summary as to the relief you're seeking. Next, show me what efforts you've made to meet and confer on these issues. Third was, tell me what are the agreed upon facts, so I know what we're really not fighting about. And then really give me the issues that are in dispute, especially if there's a linchpin. What's a key issue that I as a judicial officer would need to know in order to resolve this case or make an appropriate ruling on the case. So I thought those are always good to remind people of, including that stuff in the memorandum of points and authorities. One of the other things I like to do in my judgments is add a section in the judgment itself that talks about what are the factors that were relied upon in entering into this judgment. I usually put it in the child support section and then reference it in the spousal support section, so that if there needs to be, when there needs to be a showing a change of circumstance, we already know based on what's in the judgment, a lot of the facts that I don't have to prove them up again. It's right there in the judgment. I usually do it sort of in a way of a disomaster, in that sort of what would normally put in a disomaster for the factors. But I've seen it lately where the 4320 factors are actually put in that section. Problem is, of course, people are going to argue over what are the 4320 factors. And sometimes what I've done is say, this is one person's position, here's the other person's position. But it really then shows what the circumstances were when the judgment was entered, makes it easier to show a change of circumstance. One of the other things that maybe is relevant here is some kind of demonstrative evidence or charts. What are your opinions on use of those in this circumstance with the modification of support?
Judge Roberts, do you want
to? So first of all, and this is kind of a consistent theme, I think, anything that you can do to make it user-friendly, to make it visually easy to understand what you want to focus on is really helpful. And I personally I think charts and demonstratives and other things are very underutilized. I also want to say, just going back to what Brian said a moment ago, on the meet and confer, if you don't do that beforehand, you're obviously going to be asked, I think, in just about every courtroom to do it when you get there. The difference is going to be that it's frustrating, candidly, when you're preparing to not really know what to read. And it's frustrating because you don't know what to focus on in the voluminous materials that you've been presented. And that, of course, puts lawyers at risk of not getting an optimal result. So the dream scenario, which does happen sometimes, is to have a meet and confer that tells you what the points of disagreement are. So rather than read 50 pages and then find out the next morning that what's at issue is whether to impute income to the supported party, it's nice to know that before you read all the extraneous stuff. Sorry, I got off topic there, but I think that's really important to add to. It goes in the same category that we were talking about, which is how to make things easier. So a chart to show before and after what the judgment says, the relevant factors are, if the judgment has been done in that careful way or after trial. Sometimes it's not possible to do a judgment in that way because it would make the negotiation impossible. But do the best you can to lay out in a visual way exactly what the points of disagreement are and exactly what your evidence is. I think it's incredibly helpful.
Would that be in the format of a side-by-side, like a joint statement filed by the lawyers? Statement,
Well,
like
that's
one column petitioner's position and the second column respondent's position?
if when counsel are able to do that, very often that doesn't happen until the court orders it. But that's the dream scenario, and that's what I'm going to make when I'm preparing. I'm going to turn the briefs into my own side by side. So it's nice to have that done beforehand, and it's nice. It reduces the possibility of error. So yes, if you can do that on a joint basis, fantastic. What's so difficult in these and so many other cases is you try to talk about A, and then the other side responds by answering to talk about B, and you can't tell, is that because they don't want to talk about A, they don't have anything to say about A, or because they think B is the better argument? It avoids all that. It lays it out in a very clear way. So yes, joint is great. Separate is often the best people can do.
And I would just add, in addition to side-by-sides for charts and graphs, also there might be, in the right case, other things that you can show visually, such as income changing, and that can be very effective if, when you, instead of having just a page full of words and numbers, if you have a graph that goes up or a graph that goes down or whatever it might be. I know not every case justifies that or would be important, but I think that can be helpful. I always knew when I was practicing law that judges don't have that much time, but when you get on this side of the bench, you realize just how true that is. We're busy in court almost all day and doing seminars like this or during lunch. So we're preparing, at night and on the weekends. And so, you know your case so intimately well, and we want to do the best job we possibly can, but everything that you can do to have attachments, attachment A, relief requested, 1, 2, 3, 4, 5, right after your, FL 300, all those kinds of things just really helps.
One of the questions, by the way, is how can we include meet and confer conversations without violating settlement discussion rules? Do we briefly touch on that here?
I'll just say that I have seen plenty of meet and confers that redact, the content of any substantive settlement offers. So certainly, if there's a settlement offer that's made, you want to be sensitive to that, but you can say, these are the efforts that we've made. We made an offer, don't include the offer, and then either what their response was or the fact that there was no response. It's one way to handle it.
Yeah, I agree with that. And I also think that when you're talking about foundational facts, the meet and confer, and this is probably a good time to talk about the standard order that's issued in post-judgment requests for orders, which kind of lays out a roadmap and requires a statement to be filed by the court before the hearing to help the court know that a substantive meet and confer has taken place and what the issues are that have been resolved, including any stipulated evidentiary facts. That requirement, quite frankly, very often is observed more in the breach, but it can be so helpful. We do have colleagues, and I won't speak for Judge Richardson, but I wasn't one of them, but we have colleagues who will automatically deny a request for order that doesn't include that. And I understand why they do that. I've never taken it that far, but what that requires, I think is very clear. And I think it's also consistent with what's required in the rules of court, is a meet and confer about evidentiary facts. So the typical way of dealing with the problem that the questioner asked about is we met and conferred and we weren't able to agree. Okay. Do you agree it was a 13-year marriage? Do you agree that bomb? Very often you'll get 9 yeses, right? And so it's like, okay, well, I feel like I'm presiding over the meet and confer that should have happened, which is great, but that's what I'm trying to do when I do that is kind of, I guess, make the point of how to have a meet and confer. So in other words, you don't have to say we offered $15,000 a month and they offered $18,000 a month. I don't want to see that as a judge. That's one thing that we can put almost anything out of our mind. And I have had to put that out of my mind. That's a hard one. So I don't want to see that. But I do want to hear about the efforts to focus in the argument on what's really in dispute so we can hone in on that. If we have to have an evidentiary hearing, it can be shorter. And that is, especially given the current state, and I think the perpetual state, for one reason or another, of scarcity of judicial resources, you're doing your fellow members of the bar and other litigants a huge favor by helping us maximize the use of those resources.
I do also want to point out that Natalie included at I think the last page or the second from last page of the materials, a chart on a side-by-side of the 4320 factors. Is that correct, Natalie?
Yes, it is page 27 in the appendix.
And I sometimes have that open. I have my own version that I made, and I'm sometimes taking notes on that during the hearing.
Mm-hmm.
Yeah.
All right, shall we talk about change of circumstance? You know what, before we get to that, I want to say one of the things we have to understand is that judicial officers have incredible discretion. And so I know that that is what really is the standard, because if you think you're going to appeal a decision on what spousal support is, it's abuse of discretion. And that's really hard. So bear in mind that we have an audience of one that we have to be aware of and be understanding what that judicial officer wants to do. So one of the best things we can do is know your judicial officer, know their likes and dislikes, and whatever you want for your format, know what that judge wants and try to comply with that format would be my recommendation. So sorry, just wanted to add that one last point. And then let's talk about maybe change of circumstance, what's needed to show that there should be a modification of support. Anybody want to?
I wonder if we could get some input from the judges. You know, how much would the supporting party's income need to decrease or increase, or the supported party, their needs increase or decrease before, you know, in order to establish a change of circumstance? Is there a certain percentage? Obviously, I think 50% loss of your income would be a material change. But what about 20%, 10%, 5%? You know, where is the line that you guys might draw before finding that there is or is not a change in the circumstances?
Well, I don't know about Judge Roberts. I definitely don't think I could give a number like that. It depends on how large the spousal support award is. It depends upon, you know, how long they've been working and, you know, how long, so many of the different factors. I don't know that I could give a bright line. You know, we have discretion, I think, for a reason, because every case is a little bit different. But I don't have a number in my head. When I see it, I usually, when I see requests that I've granted, I think they are pretty considerable, like something where you're not just talking about you know, a promotion or a, you know, small increase or small decrease. But what that actual number is, I don't know. You know, so many of them are tied to big events like unemployment, or, you know, the economy crashing from COVID, or retirement or failure to, get the employment that the spouse was supposed to get. So many of them are tied to those kinds of life events rather than just incremental changes in income.
And maybe it would help to include in the underlying stipulated judgment, the parties could possibly agree that an X number of percent increase or decrease will constitute a material change for purposes of later modification proceedings. I don't know how easy it would be to get both sides to agree on a percentage, but might be worth a try.
And you do see situations where people have stipulated, it's not common, but I've definitely seen it where they've stipulated that certain things would or would not constitute a material change of circumstance, and that can be helpful. And I completely, it goes to Brian's point a moment ago about discretion. I completely agree with Judge Richardson that I don't have a hard and fast rule, but you are looking for something material, right? And what does material mean? That's inherently a judgment call that you have to make. One of the reasons, and the side-by-side can be helpful in terms of having the counsel do it jointly. But the other thing that's really convenient for a chart is compare then and now, right? Just lay it all right out. So again, so that you're not making the judicial officer try to figure out what you might mean. It's all right there. I've also seen situations where the argument, as an example, just to pick random numbers, where at the time of the separation and the judgment, the supporting party, let's say to pick a high income earner, is making $750,000 a year. Over the course of the next several years, it goes up to $1 million. Then it goes back down to 750,000. And he's in court saying, I've lost a quarter of my income. I need to modify. And so that sometimes having that chart, I think, can help lawyers focus on where they have an argument and where they don't, because that's going to feel like to him, I'm assuming incorrectly that him is the supporting party, but for purposes of my example, it may feel like he's lost income, but he hasn't relative to the judgment. So putting it all in a visual way will help us see, but there may be other things that have changed materially. Anything that is enough that would be something that would be felt in the individual's lifestyle that's probably my rule of thumb for materiality, but it's very much look at the whole picture, see all the changes they're arguing, and ask yourself, is that enough?
So if a party is, to your point, if it's felt and there is a current support order in place that requires a party to pay X number of dollars in support, and their income has decreased and they're unable to continue paying that amount, I know that I have spoken with a lot of colleagues whose clients, because they can't afford to pay the full amount, they're paying a reduced amount. Meanwhile, they file an RFO to seek a reduction in the support amounts. And then the other side counters with a contempt proceeding, which then statutorily cuts in front of the RFO. So is there any advice or input that you guys can provide to we as attorneys who are in that circumstance, whether on the party side filing the RFO or on the side of the party who is or wants to file a motion for contempt?
Do you want to take that on? You want me to start?
Go ahead and start. I've been talking too much.
No, I think it's definitely a challenge, and I have seen it happen both ways. I've seen it happen where one party files the OSC rate contempt, and I've seen where the other party says, we disagree, but let's just litigate the issue. And so, I don't think there's a perfect answer. I do think that that's complicated. I think that we as judicial officers look at the reasonableness of the conduct. If the party is cutting off completely, even though they can afford to pay a reduced amount, that's not very reasonable. If they are paying a reduced amount and they're showing all the evidence of their inability to pay, and the other side is insisting on an OSC, that doesn't seem very reasonable. I mean, just on those facts. So we're looking to see reasonableness here and which party is jumping the gun and insisting on something that doesn't make sense. And if one party is saying their income is down but is not providing any evidence of it, and there's a history of failure to pay, I might feel very differently about that OSC rate contempt. But if the party has been paying faithfully and shows a bona fide change and shares it all with the other attorney, then I feel very differently about that OSC rate contempt. So I think touchstone is still reasonableness, and how is your conduct going to be perceived by the judicial officer?
I agree with that. And one thing I wonder about, so very often you'll have an RFO that's been filed, then you'll have the contempt filed. You haven't even arraigned on the contempt. And then what happens is the party who's seeking to modify asserts his or her Fifth Amendment rights and stops the RFO proceeding in its tracks. And I've always wondered, I've only had a couple of situations where the party was willing to talk to me in any depth, because there, even though the contempt has precedence, just procedurally, I'd be able to make interim orders if anybody would give me anything to look at. So maybe there's a good reason why practitioners don't do that. Maybe they're so worried about the Fifth Amendment right, or I can imagine malpractice concerns. I can imagine a lot of reasons. But I have had situations where people have waived their right, asked me to hear the RFO on the date that it was scheduled. So that's a long-winded way of saying I wonder if sometimes it's not self-imposed, at least to the extent that the party could reasonably waive Fifth Amendment rights and be heard. Do you, by the way, Brian or Natalie, do you have a sense of why that's not done more often?
I think it's fear that you might be doing something wrong that would lead to malpractice. You would like to be able to say, let me put the information out there to modify support downward so that maybe I am paying within the range where I'm supposed to be paying, and then I wouldn't be in contempt of court. But if the court doesn't modify, then you've admitted to being in contempt of court, and then you're going to get sanctioned for that admission. And then your client's going to turn around and say, why did you let me admit that? And then you're going to get tagged for having done that. So it's depends on how much risk an attorney is willing to take, or how much they think there's going to be a modification, and whether it's worth submitting the information on the hopes the support gets modified downward, and then maybe the payor is not in contempt of court.
I agree with that. And I also think that it a lot of times depends on the client. If they are truly unable to pay the full amount and have made reasonable good faith efforts to resolve the issue before going to court, and the other side comes back with a contempt, then they want their requests heard, and they're not going to be willing to waive the Fifth Amendment and proceed on a quasi-criminal proceeding when they're truly unable to afford to pay and they did file first.
There's also a fear that maybe your client's not being honest with you and giving you all the information you need, and giving the information that the court needs, and then it would come out later, and then you as the attorney look bad, and you would have given different advice had you known more of the facts. But you can't always trust your client to have given you everything that you need. So it gets to be very risky by an attorney to give that information to potentially reduce the support downward, and that becomes an issue.
So going back to, what is a material change in circumstance, and in light of the pandemic and the uncertainty in for both sides regarding their income, are the courts considering or ordering, Smith-Ostler or even a reverse Smith-Ostler, so that way, the court can ensure that there's a fair and appropriate support order made that ends up being accounted for at the end of the year, as opposed to making an order that is certain and, either one side is unable to pay it, or it turns out their income goes back up and they are able to pay, and the other side is prejudiced because they are not receiving the full amount of support that they should be.
Let you start on that one, Judge Robin.
Okay. So without perhaps answering that question directly, this is very challenging, right? And it's something that we've all dealt with a lot. And you try to figure out what options you have what tools you have in the toolkit that will help you solve the particular problem before you. It is a situation where you really would like, if there are good lawyers involved, for them to try to see what they can come up with in terms of a structure, in terms of a form, because they have I should say a formula, because they have so many more tools in the toolkit than you have. But I've tried to lead discussions with lawyers to come up with what feel to me like business-like solutions of that. When that doesn't work, there are a few things that you can do. One thing that I did a lot, and I know other judges did not, is I would, especially during that period of time when you recall we had the categories 1, 2, 3, and 4 of the cases that we were hearing after the court reopened everything in June. Well, post-judgment modifications were near the bottom of the priority list. So people would come in, I wouldn't have time to get to them, or sometimes they would even come in ex parte because what they had been, they had asked to be heard in August had been continued out to December or January. I would really, on ex parte, I would set it for a hearing. In other circumstances, if they happened to be there and I was going to see them for a minute, I would look and take testimony and see if there was a basis to make some kind of an interim order until we could get back in and try to find the sweet spot. I was amazed at how often, it actually happened a lot, where the party would come in who was seeking to modify and say, look, I don't have a job. I hope to have a job. I'm not looking for anything other than just to get out of the jam I'm in right now. I think I'll be out of it in X period of time, and I'm willing to pay this in that period of time. And it would just kind of organically work itself out with a little bit of discussion. When it didn't, I didn't know what to do except make the best interim order I could, kick it down the road for a few months and see the situation. I know other judges whom I respect very much were just making modifications based on what was before them. And if they want to modify that, then they have to come in for another request. With high income earners, I did do a couple of Smith-Ostlers to try to deal with that.
Now, I will just add to that. I think that's really good advice. I would just add that, I feel like we really do look to the attorneys to give us your best input about what you think that structure should be, because it could be a variety of things. And if you can come up with a proposal and a suggestion that can help trigger us about what makes the most sense for you, whether it is just a temporary halt or a decrease or a coming back in 3 months or 6 months, or whether it's a Smith-Ostler, or each party giving each other the information about their employment situation or their income situation. I've made various rulings with various cases, just depending upon how much the lawyers are willing or have the ability to come back into court, or whether they want it to just, not be another hearing because their client maybe doesn't want to pay for another hearing. So then I can just say, then you're going to need to keep each other apprised of your income and, meet and confer and, reinstate it if the income comes back. And if it doesn't, somebody brings an RFO. So I've done it in various ways, and I just try to tailor it to what seems like the best for that family, how expensive, how much support we're talking, that kind of thing.
I want to emphasize what Judge Richardson just said, because those are the same comments I wanted to give. A lot of this has to do with attorneys working together. When there's a tragic situation and somebody's claiming their income is down, there's probably distrust on the person who's receiving the support not to believe that. And one way to handle that is work together. Maybe that comes with the person who's paying support having to give some of their financial documents that they don't want to have to give, and give it on a regular basis. Give me your monthly statement so I know whether your income is coming up or down, and maybe we can go back to a regular order. Maybe we'll reserve jurisdiction to go backwards and have a stipulation that we can go backwards in time in trying to modify the order. But a lot of attorneys can work together and avoid the need of having to go see the judge on this issue if they're willing to make some sacrifices on disclosure. And I would recommend that to people as a way of trying to handle the situation and seeing if you can modify by agreement or by looking at things, or Osler smithing something later by doing a true up at a later time.
That's really well stated, Brian and Judge Richardson. I echo that. And I think, one of the most common, again, I was kind of amazed at how many of these were relatively easy to figure something out on with a little bit of guidance, a little bit of input, a lot of input from the lawyers. The tough ones were the ones that it was the fifth request to modify in the last 2 years, right? And there's no trust in it. And it's like, he's using this as an excuse. It's yet another. Those are really tough. And I think that's really sound advice, Brian.
Yeah, and it's difficult because I know the riddle, you're going to have to look at 1 year's worth of income to see whether you should modify downward. You're saying, well, something's happening right away. It's not over a year period of time. And what should we look at? And that's a difficult situation, but it's really up to the attorneys to see what they can do to do what's fair and what's equitable. Isn't that what we're really all supposed to be doing, is trying to do what's a fair result for people as well, even though I know we're supposed to represent our clients, but being fair with one another is maybe being a good advocate for your client. We forget that at times.
We appreciate that when you do.
Yeah.
When you talk your client out of taking an unreasonable position, we know that happens all the time.
And that's part of being an attorney, is telling your client no. And it's oftentimes that's the difficult part of being an attorney, I think. One of the other changes of circumstance that's common post-judgment is inheritance that happens. And I know people will say, well, that person just inherited money. And I think one of the things that people forget is that there has to be income from that inheritance in order to effectuate and being a change of circumstance. And just the fact of inheritance doesn't necessarily arise to a level of a change of circumstance. Would you agree with me on that subject at all, or want to comment on that?
Yeah, I agree. Obviously, your statement of the law is accurate. I think where it gets tricky is if it's a really substantial inheritance, then the question becomes, is there a basis to impute income? And that's where I've seen people try to get around it, depending on the nature of the inheritance. But what matters is not the inheritance, but whether they're getting income from it. So if they have, just an example, they inherit a farm and they choose not to use it as a farm, I'm probably going to impute income on that. If they inherit a $10 million painting that's hanging on their wall, I'm probably not. But it's even either of those circumstances, discretion could lead me in a different place depending on exactly what was going on. But they're very different kinds of inheritance.
And another thing that happens change of circumstance wise is that somebody doesn't try to get a job subsequently, and the other person says, I've been paying support long enough. And I know there's fights that happen over whether you can put a Gavron warning in a judgment at the end, and people want it in because they think you can't terminate support without having given the Gavron warning under Schmier. But I think that that becomes an issue when somebody's not making effort to become self-supporting. And I realize it's one of the 4320 factors. Do you guys have any comments on the play of Gavron and modifying support post judgment?
Right. Well, I definitely do see these. And, I think it's particularly effective when somebody can come in and point to the number of different places where a party has been, warned, whether it was during trial, maybe it's in the judgment, maybe it's not, maybe it's in a minute order during a hearing, or whether it was, and in whatever context it is, reminder, particularly if there was a trial, and if the court did say that I believe that within X number of years, somebody should be able to find employment, that's kind of persuasive. And so unless there is a good explanation as to why, if there's been subsequent facts, illness frequently is alleged, or something like that, then, you have to consider those facts. But, I think those warnings are put in there for a reason. I think the legislature understands, wants us to apply that law. And so, I do think it is persuasive, unless there's a good reason not to.
Well, perhaps age may be a factor in whether a Gavron warning is appropriate or not appropriate.
Right. Well, that's why I say, especially if it's already been made. I mean, if somebody said at a certain point, this individual is, 48 years old and has X degree and, I believe can work. So if at the time that the judgment was entered, whether it was a trial or whatever it was, particularly a trial, I guess, in this context, that statement was made, then that's something that we can pay attention to. If, on the other hand, it was never mentioned and it wasn't specifically adjudicated, then you do have to look at, how long was this marriage? The other factors, was this person primarily a homemaker, and did they primarily, help the other parent, with their career and sacrifice their own career? And so, and then they get to the point where they're too old to be able to get a job. That's a completely different scenario.
And then I think pretty typical of a change of circumstance, trying to answer a question here, is retirement comes up, and people think I don't have to pay support anymore because now I'm retired. And I think people realize that don't quite work that way. Any comments on that?
Well, I'm familiar, there's like a variety of cases that are out there that sort of say, well, what is a reasonable retirement age? So if you retire before retirement age, then you may have a problem. You may not be able to, get away with modifying it because you chose to retire before retirement age. On the other hand, if, as in the, I can't remember if it's Shimkus, the firefighter, normal retirement age was 55, and so that was legitimate. And I know there's other cases as well about, if one person retires early and the other party then gets some of the pension benefits, then maybe you still impute some spousal support, but you decrease it by the amount that the other spouse is getting in the pension benefits. So I think, you do have to figure out whether or not you're at reasonable retirement age for your industry. Put that into the record.
I think I think that's probably, it's definitely top two, probably top one, right? Reasons for request for modification of spousal support. It's way up there. And so you see a lot of different examples. One thing that I've struggled with a lot that I think is an opportunity for a practice pointer or not, maybe sometimes it's better to not raise an issue that you can't really deal with. But when the parties have gotten divorced at 62, and now the supporting party turns 65, I'm always asking myself, well, what were they thinking when they entered into this agreement 3 years ago? Were they thinking that that he was going to retire and it was going to continue to be the same? Or were they thinking something else? And you really don't know. And so it would be really helpful, especially when people are near a normal retirement age for the industry, to get to think about that and to include something, if you can, about what the party's intentions are.
I heard recently that there was a judicial officer that said somebody retired early because they retired before they were 66 years and 2 months, because that was when you could start to receive the full amount of your Social Security, so that the age got bumped from 65 to 66 and 2 months. I thought that was pretty clever.
I think until the California Court of Appeals weighs in, you know, that's going to be up in the air. And I judge.
Yeah.
Tough one.
So when a party moves to reduce support because the supported party, they believe, has not made reasonable and good faith efforts to obtain employment, what sort of evidence are you guys looking for from the supported party to show that they have made good faith and reasonable efforts to find employment?
Well, I'll start on that one. You know, obviously it's helpful to have those applications, those letters, those job efforts shown to us, and or if it's that they say they can't anymore, then to show the doctor's, you know, reports or whatever the disability is that's preventing them from working to be shown. You know, it's surprising to me how often you just hear you just see the declaration that just says, I've tried and I can't, and I'm sick. And it really helps to have some supporting documentation to go along with just the bare bones declaration. I don't know whether it needs to be an evaluator. I don't tend to think it does in this kind of a context, just based on the facts you said.
I've seen a lot of cases where the supported party, they don't make, maybe they do, but they end up enrolling in school, right? So I'm going to go be a therapist. So I'm going to go to Pepperdine. It's going to take 2 years, but I'm going to make a lot of money, you know, after I finish all of my hours in 3 years. And do you guys consider that a reasonable excuse to not have their support decreased?
Well,
So
go ahead,
please.
I was going to say it really depends. I mean, I've had cases where the person had a degree in psychology and maybe they had been working towards that in the past, and then they kind of paused everything during the marriage, and then they want to go back and finish it and get a license. Or you could have a situation where someone, you know, just picks a random profession that doesn't, you know, that they want to go and get more education. They want to get suddenly a PhD in something, or and you might say, you know, is that really the best use of your skills and your talents that you have? Is that how soon are you going to be earning what kind of a salary? So, you know, unfortunately, again, it does depend on the circumstances, whether that feels reasonable. And so for the exact same, you're sounding a little skeptical. I can see if you just had a bare bones situation with someone going to get a degree and it wasn't included again in any trial. I'm surprised how much there are transcripts of what the court found would be a reasonable direction for the person to get further training or education in. So we look to all of them.
One thing I'd like to point out before, I'm sorry, Judge Rob.
Oh, go ahead, please.
I was going to change subjects, but if you're commenting on this, maybe go ahead.
Oh, yeah. I was just going to say, I very much agree with everything Judge Richardson said. I think that you can tell if it's a real effort or if it's a personal growth opportunity. You can just tell, and that's where the discretion really comes in. I've had numerous cases where the supported party wanted to go to nursing school, and you know that's a career where you can make a good income after a relatively short period of time, and 2 years later, she's got a good job, and so it feels very reasonable. You see other situations where 7 years later, there was something that happened with the program that you're talking about at Pepperdine, and they got distracted by this, and you can just tell. So I think all of those things go into discretion. One of the things that that I think, I know it's something that I struggle with, and it's something that I try to figure out when it's appropriate to take into account and when I need to filter it out in terms of exercising my discretion. There is a complete difference between the party who is the supported party who is driven by economic desperation and how quickly that party finds work, and the party who is not in that situation. And so sometimes I can't help but compare the effort of the poor person with the effort with the wealthy person. And the struggle is what part of that is legitimate. I mean, the marital standard of living is a factor, but you're also required to become, to make reasonable efforts to become self-supporting. So I think it's important, as you are trying to explain why a particular effort is reasonable, to bear in mind that we see people making Herculean efforts, successful Herculean efforts all the time.
I want to say that one thing that a number of attorneys don't realize is that under 4326, when child support ends, there's a window of time that you can file a motion to say that's a change of circumstance to modify spousal support. But how do judicial officers feel about that? Just because child support ended, should spousal support be modified if no other factors have changed?
Yeah, I really, I've had that, and I sort of asked, which way does that cut? Because, and I can't recall now if I found case law on point, but theoretically that increases the amount of income to the person who is paying child support. So, depending upon what your argument is as to why that's a change of circumstances, you got to think about which direction that's going to cut.
Is there any thoughts or comments about how quickly you can file a motion to modify? The judgment was entered and 2 months later you're filing a motion. Does that affect judicial officers as how quickly these modifications come and go?
Yes, there's no doubt. I think that there is no magic number about when you can, because it does depend on the facts, but it is very frustrating because the whole purpose of having a change of circumstances is that you're not relitigating everything. So, I do think you need to wait a little while to sort of, otherwise, I mean, unless crisis happens right afterwards, right? I mean, so again, there's no magic answer, but if it's just your income and then all of a sudden you feel, and the other thing I've seen sometimes is where the parties have been negotiating for a long time and then the judgment's entered, and in their mind, they're still thinking about the beginning of that negotiation that happened 2 years before that, but the judicial officer is looking at the date the judgment was entered. And that's when the change of circumstances is judged by. So that's something to think about.
I'll ask one last question, and we can make this very quick because I know that we are out of time, but I think it's an important point. The cases on child support that discuss what is and is not income, for example, Alter with the recurring cash deposits of $6,000 a month versus in that case, it was the father who was his mother, so the kid's grandmother, was also paying for private schools, summer camp, etc. The court did not include those, but did include the $6,000 a month. And then there are obviously several other cases that relate to child support only that help define what's income and what is not income for purposes of child support. Are those cases persuasive on the issue of spousal support in determining income for either or both parties?
You want to answer that?
Sure, if you want. To me, those cases, first of all, a lot of times those cases are brought up as controlling authority, right? In other words, the distinction between child support and spousal support is lost. And it doesn't really get discussed by either side. So in that circumstance, obviously, I would consider the arguments of each side. I think that because the supported party's need for support is a relevant inquiry, that at least to the extent that, like in marriage of alter, you have a long established pattern, that does go to the need for support, and I would consider it under that factor. I do not know of any law on that one way or the other, but that has always felt to me like a reasonable exercise of discretion under that factor.
I would just add that, sometimes the opinions, but rarely do they sort of distinguish and talk about the purposes for child support. Remember, like in marriage of Hine, which we talked about in terms of shifting the burden of proof. When they talk about shifting the burden of proof, they do talk about one of the factors is the policy towards child support. So you could see a case where, I don't know if the result would have been different if it hadn't been, but that's certainly one of the factors they talked about. So unless the case makes that specific distinction, again, I would hear the argument and hear the positions of the parties about that kind of a case in a spousal support situation.
Any last question about cohabitation? I know people think, oh, they're living with another person, so I shouldn't have to pay support anymore as a typical complaint of a payor. Any tips or observation in that regard?
I mean, mine is that I hear that a lot and I don't often see admissible evidence of it. So if you believe that it's happening, you need to have some kind of evidence that isn't just your, child is telling you, that, which is usually what it is.
Yeah.
Yep.
So I just think you need some real bona fide evidence of that, and then we'll consider it.
If there's an admission that, by that party who is cohabiting with a non-marital romantic partner, and they end up in an expense sharing, arrangement, how do you as the court consider the cohabitation in terms of reducing support? Is it dollar for dollar? So let's say the non-marital romantic partner is, say, paying rent, but then the supported party is paying for other expenses that may or may not offset it. Is it a dollar for dollar, or how do you guys determine how much of a reduction, if any, is permissible?
Again, facts change. So I've had situations where they claim that the cohabiter is not working and isn't contributing to expenses, and other situations where they're very wealthy, but there's a disagreement as to whether they're actually cohabiting. Or maybe they're paying, as you said, some of the expenses, but not all of the expenses, then a dollar for dollar might make sense. But it's more that I just rarely have admissible evidence of it. It more falls into this sort of, she always says he's driving a new Tesla. That's how I know he has more money. And he always says she's living with a new guy, and that's how I know she doesn't need the money. And we'd like a little more, meat on the bone.
All right, I think we're out of time. I wish we could go all day, and probably we could if we had all day, but Judge Richardson and Judge Roberts have to get back on the bench, and we thank them very much for their time, and we thank all the attendees for our participants for coming, and hope you enjoyed the program. Thank you very much.
Thanks so much.
Thank you.
Thank you.